Dear students, let us continue with our next doctrine, which is Doctrine of Precedent. It is also called the Doctrine of Stare Decisis. This doctrine is important in those countries which have a judicial system in a hierarchy, or which is also called as a pyramidal judicial system. A pyramidal judicial system. Now, we all know in India, we have a three-tier judiciary, whereby first we have the subordinate courts, then we have the high courts, and at the apex level, we have our Honorable Supreme Court. This doctrine says that whenever any higher court has already settled a principle of law, a question of law, any legal issue has already been settled, then all the other lower courts in the country are bound by that order, are bound by that verdict. This means if any question of law, if any question of law has already been settled, in future, when similar cases or cases involving similar question of law reach the same court or the lower courts, then the courts have to give orders, the subsequent orders, keeping in mind the already settled principle of law. So this concept simply means that what is already settled, please don't unsettle it. Please don't unsettle it. Now, why is this concept so important? This concept is important because this concept allows to maintain a consistency in our judicial system, which is very important because this consistency allows to develop a faith of people, the confidence of people in country's judicial system. Otherwise, what will happen? Imagine if I go to the court in some matter, in some legal issue, and the court gives a verdict. Let's say you also go to the court. Of course, it has your concern, your matter is involved, but the question of law, the legal issue is the same. And in your case, the court gives a totally different verdict. That means there is lack of consistency in judicial verdicts, and that will erode, that will hurt the faith, the confidence of people in judicial system. That is why this doctrine is very significant for the judicial system and for the people to have faith in our judiciary. Now, in our constitution, this principle also flows from article number 141. So, after watching this video, or you can pause this video and you can check article 141, it says that the law declared by Supreme Court, the law of Supreme Court is binding on all courts of the country. Now here, please don't be confused. We know that Supreme Court is not a legislative body, but the language used in Constitution is the law of Supreme Court. Here the word law refers to the orders of Supreme Court, the interpretations of any law given by Supreme Court, or any judgment given by Supreme Court, right? These are what we are trying to say mean the word law of Supreme Court. So any order passed by court, any interpretation of Constitution or any other law given by Supreme Court or any judgment of Supreme Court is binding on rest of the courts of the country. So rest of the courts will deliver the verdicts, they will dispense justice according to these judgments, interpretations and orders of Supreme Court, because they are bound by doctrine of precedent, right? Now, this concept also allows us to maintain what is called rule of law. Rule of law. And you all know rule of law means there should be absence of arbitrariness. Right? Now, one more thing, remember that this doctrine is also called the rule of finality. The rule of finality. That means once the higher court has given a verdict, it is considered final, and it is binding on all the other courts of the country. Now remember that Supreme Court itself has held that the order of Supreme Court has twofold significance. First, it is decisional for the parties involved in the case. That means for that particular case, that is decisional, that particular order. But for future cases, that order of Supreme Court is declaratory in nature. So when you will find these words in Lakshmikant, if you are referring to this chapter, please don't be confused. So let's say if I go to the court in some matter, the court gives the verdict. So in my matter, that order will be called as decision of the court. But for future cases, in similar question of law, that order will be called as declaratory. But remember, this doctrine does not mean that if Supreme Court commits a mistake or any higher court commits a mistake, it is not ready to rectify that mistake. No, because it is popularly said that it is wise to be ultimately right, rather than to be consistently wrong. That means no doubt that we want to have a consistency in our judicial system, but that consistency cannot be based on faulty reasoning. It could not be based on faulty grounds. That means if the court is convinced that in a previous case the court has committed a mistake, or any fact was not available at that time, or any new evidences or new reasoning has come up, then the court can definitely review its own order. That is why Article 137 of our Constitution gives Supreme Court the power to review its own judgments. That is why you all know, and when the court has given any order, it accepts something called as review petition. Now, even if this petition is rejected by the court, then also you can file a petition called as curative petitions. So this mechanism court has involved just to make sure that in cases where the court has genuinely made a mistake, then the court can change its own decision. Otherwise, the general principle followed in our judiciary is what we discussed, that what is already settled, it should not be unnecessarily unsettled. So this helps us to maintain consistency in judicial system. It helps people to have faith, confidence in judiciary. It helps to maintain rule of law and leads to no arbitrariness. This is called rule of finality. And two articles which are important are Article 141 and Article 137 of our Constitution that we discussed. I hope this doctrine is clear to you. Until next time, bye-bye.